The customer service advisor read out the terms with the particular confidence of someone who has said the same thing many times and has never been challenged on it. 18 months minimum term. I was 4 months in. I could not cancel without paying the remaining 14 months up front, approximately £490. I had joined the gym in January with the intention of going regularly. I had gone regularly for 3 months, and then my circumstances had changed significantly. I had taken a new job with different hours and a longer commute, and the gym I had joined was no longer accessible in any practical sense. I was paying £49 a month for a facility I could not reach. I asked the advisor whether there were any circumstances under which the contract could be cancelled early. She said there were serious illness or injury with medical evidence, or redundancy with evidence of job loss. My situation, a change of job and commute, didn't qualify. I thanked her and ended the call. Then I read my contract and looked up the relevant consumer law. What I found changed my position entirely. The Consumer Rights Act 2015 requires that contract terms are fair. A term is unfair if it creates a significant imbalance between the rights and obligations of the parties to the detriment of the consumer. The Competition and Markets Authority has published specific guidance on gym contracts. That guidance identifies minimum contract terms of more than 12 months as potentially unfair. My contract was 18 months, significantly over the threshold the CMA considers acceptable. The guidance also identifies as potentially unfair any clause that requires a consumer to pay the full remaining contract value as a condition of early cancellation, without any attempt to mitigate or reduce that sum. My contract had both an 18-month minimum term and a requirement to pay the remaining balance in full to cancel early. I wrote to the gym's head office. I did not write to customer service. I wrote directly to the legal and compliance team, citing the Consumer Rights Act and the CMA guidance specifically. I said I considered the minimum term clause and the early termination clause to be unfair contract terms and therefore unenforceable under the Act. I said I was giving 30 days notice of cancellation with no further payment and invited them to take the matter to court if they disagreed. The gym's response came from a different team than the one I had spoken to on the phone. The tone was noticeably different. They said they had reviewed my account and noted that I had raised concerns about the fairness of our contract terms. They said they wished to resolve the matter and were prepared to accept my cancellation, with 1 further month's payment as a goodwill gesture. I countered that I was not making any further payment on the basis that the terms were unenforceable, and that I was reporting the contract terms to the CMA for review, regardless of the outcome of my individual complaint. They cancelled the membership, no further charge. The CMA complaint I filed anyway. 18-month gym contracts with punitive early exit terms are not an individual problem. They affect everyone who signs them and doesn't know they have the right to challenge them. If you're stuck in a gym contract with a minimum term over 12 months, the CMA guidance is on your side. You don't have to pay 14 months to walk away. Has a contract ever trapped you in something you couldn't get out of until you knew your rights? Drop it in the comments. And if you want more complete stories with no part 2s that never come, follow the page. New story every day.